But if it's a securities that's worth $100,000 and you're not paying tax on the gain and you get to use the receipt against other income, it's going to cost you this much, this much less, so that you get more benefit. So it in fact, I think, and I'll be fascinated if you get the financial information, and I hope it gets to be shared publicly, because it's a question we always want to know. But I mean, I would think that it has some impact, but it's not necessarily that it's all in addition to what are otherwise the cash donations.
Cooper?
And from a practical perspective, when does this discussion come up? It comes up usually with a wealthier person at, not quite retirement, close to, and the conversation is, what do I do with these assets upon my death and just prior to death? And the standard script is, so what are they? And you go through asset by asset by asset, and it's a very deliberate exercise to sort of minimize tax and come up with plans to deal with assets to, minimize tax in effect, so that the most liquid is left for your heirs and for others. And we always hope for philanthropy, right? So once again, the numbers will bear out, but that is indeed the exercise, which is to go through the assets and try and deal with them in order to minimize tax. And so as soon as one group of assets gets a more favorable tax treatment, if it is gifted, then, you tend to focus the plan in that direction. So.
Senator Duffy and then Mr. Aptois.
I wanted to ask for a little more detail, if we have it, about, you made some reference, Mr. Apatow, to a pool of capital. I'm trying to find the exact quote here. Do you have any idea of how much, if we're into this transfer of shares in private corporations, you say there's an untapped pool of capital there. Do we have any idea of how much capital we might be freeing up here?
I have not a clue.
Ms. Manwaring?
I was going to say the same thing. We've been talking about that untapped pool of capital for many, many years, and I'm not sure there's really any way of knowing.
Is it worth the hassle?
Well, it doesn't mean that I think the idea is that as a certain generation gets older, there will be a transfer of wealth, and that we know that there are significant businesses, private businesses in this country that are in that category. But an actual number, I don't.
If you just take sort of an anecdotal view and walk down the street and you see, there's small mom and pop shops and there's large private corporations operating in next door, and that people have private investment companies. That there are a huge number of private corporations in every city, in every province across the country. That is the pool of capital we're talking about. These private corporations that have built businesses of some value. But if I may, I just would like to go back to the other question about whether or not an incentive of such as this would actually increase the total donations, or is this simply a question of donating from one pot versus another? And I would suggest that, again, if you have to look at the mechanism and the overall picture of the individual. One of the problems with the 2015 proposals was that you had to sell the shares, sell the shares and then donate the cash within 30 days. The difficulty is that on a practical level, a lot of small businesses have a 5-year arrangement for the payment of the total funds of a sale. So that on a practical level, people don't necessarily have the money available to donate within 30 days, and so they're not going to be able to take advantage of the incentive program and therefore not be able to donate. So they're related questions.
I'll stick with two brief questions. in previous times when finance has considered new proposals to incent charitable giving, they've sort of said, we'll do it for a number of years, we'll observe it, and then we'll think about it. So my first question is, would that caution, we're a risk-averse country, we like to go slowly, would that caution, should we apply that caution to the same proposal? One. And my second question is really the one that I ask every panel. This is a proposal that will benefit largely wealthier, middle-class donors. Is there a counter proposal that you can think about that would benefit small donors so that they too are incentivized to give more to charitable organizations and causes? Because this committee is to some extent interested in increasing awareness of the good of charitable organizations, the incentives and the donations that go to them. Can you think of something that would help us out to balance the audience here with an audience there? Oh, lots of take up. That's wonderful.
Mr. Oil.
I guess one thought is the practical reason why larger charities seem to be the only ones that would benefit from this particular concept. Maybe is that if we're talking large sums of money, that the smaller charities are sort of exempted from that because they don't have a need for, 6 figures or 7 figures. I'm sure they do.
They do.
They do, yeah, exactly.
They do.
But that may be the reason why they aren't viewed as the possible beneficiaries of it. So I'm wondering if there's a way that I'm spitballing here to perhaps an option for one of these transactions to distribute amongst multiple charities. If that's logistically that could be an option to present to potential donors.
What about the trial period?
As for the trial period, I mean, I think we can take for granted that that's a given. I mean, income tax law is under a continual state of evolution, and it's pretty clear what finance and parliament do when they have a result they don't like, is they amend the act immediately, as they're wont to do, to the tune of several hundred pages a year. And so I think that just comes with the territory. And it's actually one of the frustrations of being a tax lawyer, as any tax lawyer can tell you, is your knowledge is never complete. I do agree with the comment that, and as I alluded to, there's going to be a certain taxpayer profile that would disproportionately claim this kind of a tax concession. Just one comment on that is a bit of a pushback on whether or not that's best framed as a benefit. Mm-hmm. Relative to the status quo, it's a benefit, but I do find it there's a tendency in the discourse about this kind of a tax concession to conflate the distinction between something like a principal residence exemption and a charity tax concession. Just because people are giving property away and the tax credit's less than 100%, so you're always left out of pocket. And I think some advocates might say we'd be removing a penalty. That right now there's a tax penalty on donating certain kinds of securities and certain kinds of property, and we would be equalizing the treatment. I mean, to some extent, we've already made the decision to do this. So at this point, the question is why confine it to publicly listed securities? So I don't disagree a certain kind of taxpayer will claim this, but I'm not sure that that's it's not a tax benefit in the same way as other tax concessions.
We talked about the frustration of being a tax lawyer. What about the frustration of the legislators that end up looking at those 500 pages? And many of us are not trained as lawyers. That's a rhetorical question. Ms. Manwaring.
I've lost a little bit of the train of. I'm sorry, Senator Almodovar. The two questions. One of the points I did want to make
small
is that
charities and trial periods.
And trial period. Yes. Okay. So trial period. I mean, I think Mr. Perichin is right that the Act is always subject to review, but identifying a trial period like they did with publicly listed securities and the DQ, I don't think is harmful, because I think it does require someone to go back and look at it. Whereas if it's not obviously making a change one way or the other, they might not do it. So there's nothing wrong. The first time donation super tax credit that was introduced a number of years ago, but was removed. I think probably was removed because they did look at it and they didn't find that it was much of an incentive, or it was giving them enough of an incentive to go. So that was a situation where they tried to do something, I think, for small, like certainly to incent giving. On the smaller charities, one of the things, I mean, you could give publicly listed securities to small charities if they go through Canada Helps and that sort of thing. There are mechanisms. Education is huge in this area because I think they could get the benefits if people understood what they had to do. It's the larger organizations that have the staff and sophistication to be able to speak to their donors about it. If smaller charities had that knowledge, it would help to leveling that playing field.
Draftweiser.
So with respect to the trial period, I agree that I think an identified period of review makes sense, if for no other reason than it will certainly focus the mind of the sector on making the best use of that provision. I think another option, which I outlined, I wrote a paper on the topic for the C.D. Howe Institute where I suggested both a trial period and a trial rate, in that it's not necessarily true that the government has to say that the donation of private securities is completely eliminated from tax on the first in the first iteration of the law. They could say, well, we're going to make it, let's say, 50% taxable, or let's say 50% of the taxable capital gain taxable. Yeah, and then see what the effect is on the tax revenues and what the way forward may be. So I would suggest both of those things be looked at as trials. With respect to the issue of small charities, and I think this goes to Senator Mercer's point, and of course Professor Parichin, forget about the tax lawyers, forget about the legislators. What about the poor taxpayers that have to deal with an immensely complicated act? The act is not currently designed in such a way as to improve the benefits of giving the lower your income is. In other words, the tax credit that is available on the donation is equalized, and so because the credit is given at the highest marginal rate. I think while I fully understand where you're coming from, the difficulty is that it would complicate the act to improve the incentive for a smaller giver so as to perhaps give them a super incentive for the donation of those types of securities. It could certainly be done. It's just a question of math, but it does introduce a certain level of complexity into the administration of the act.
I'm concerned that when we talk about de-incentivizing the major donor, that if we take the major donor out of the picture, we've taken a lot of money out of the picture, and whether we like the fact that there are rich people benefiting from the incentive or not, that's secondary. Let's look at the benefit that the money is, and if we don't raise the money from those wealthy Canadians, where does it come from? If you can it only works if you're going to substitute that with a massive increase in donations at the lower end of the scale. And it's while I've always been a big believer that I really want the $100 from one donor as opposed to the $100,000 from a corporate donor, because a corporate donor is giving it to me for one reason or another. The $100 donor gave it to me because he or she believes in whatever my cause is, and that's worth a lot more than money. The agreement cost. Ms. Cooper.
So on the time period question, I completely agree with Susan. I was going to make the point that Adam made about the rate. If you remember the history for gifts of cultural property, eco-gifts, and private securities, it started with a much smaller capital gains exemption, and then it went the whole hog. I would never think that is a good idea for real estate, but certainly for private corporation shares, I wouldn't opposed. With respect to the, smaller charities, I think thinking about tax incentives is perhaps not the way to go. And that's because of the experience that was had with the first-time donors tax credit. I think that for smaller charities, it's also unfair to focus on smaller donors. And I say that, donors with less means, because the smaller charities would just as like to have the donors with more means. And the gap is one of education, access to technology. I was always struck by the mandate of this committee, which is innovation. And I think that measures that would enable smaller organizations to raise more money, if it's through, the cause marketing, if it's the phone thing, that's the, funding for creating those kinds of mechanisms is how you're going to address the need of smaller organizations to attract the dollars from more well-off donors.
Now I'm going to do something that I've always watched lawyers do, and I always wondered how they got to this point. I got to this point by accident because I read the documents in front of me. I'm going to ask a question, quoting one of you. Ms. Manwaring, in your testimony before the committee, you said it's time to permit a charity to carry on any type of revenue-generating activity so long as the proceeds are used to further its charitable purpose. This would mean the focus would be on the use to which the funds are put, not on how it has raised the money. Can somebody please explain your understanding of the destination of funds test? And how could a destination of funds test be incorporated in the Canadian federal regulatory environment? Now, Ms. Manwaring, I suppose I should give you the first crack at this, since I was mean enough to quote you at the start. So, Ms. Manwaring.
I don't mind that you quoted me. The concept of destination of funds is that you can, if it's, and it goes back in my thinking to the premise behind in the Income Tax Act that is critical to both registered charities and also to nonprofits that aren't registered charities, and that is that the wealth or the profits that are generated within the organization are not there to be then paid out to the owners and to increase personal wealth, but they're being generated for the purpose for which the organization is established. And the destination of funds concept takes that and says, okay, if you're able to make money from an activity within your charity, and that money, you're successful at it, and it doesn't necessarily, if you're an education charity, it may not necessarily, maybe fixing cars, and it happens to be that you've got a shop in the school, and somehow you've been able to generate something, a very positive income stream. Why can't you then, as long as you use that profit for the charitable purpose, why do we care that you're doing that without paying tax? And I think that over the years, my view is that the corporate world has been very successful at saying, oh, no, but that's unfair competition. And I've always found that striking, because I think, in fact, it's not. I mean, the charity wants to make as much as they can from that, and will charge the same thing that the local gas station will charge if they can do it, because then it helps them carry on their purpose more. So it's the idea that the funds are that the destination of that profit is for the charitable mission. And I know this question gets asked, so I'm going to jump into it. But in Australia, there was a decision in the High Court, the Word Investments case, where it was their Bible translators, and there was a registered charity, and they had a funeral business. And the court held that as long as those profits were being transferred and used, not transferred, but used in the charitable activity of the registered charity, that they were furthering that purpose, that was okay. And the world hasn't fallen apart in Australia, and that's really the concept. I want to make one more comment, and then I'll stop. I do think there is something to be said about ensuring the purpose is being furthered by the activity, and that you have some level of that it's probably subordinate to the charitable activity, that it's not the only thing that's happened.
Not only did you generate a question from me you've generated 3 comments from your fellow panelists. Mr. Parrish.
I mean, I think the obvious lines of discussion here are some of which have already been alluded to. Would this contribute to a problem with competitive neutrality? Would charities be competing at unfair terms? Of course, the response to that is charities can already operate through a for-profit and donate the proceeds, and thereby achieve an effective tax rate that would itself achieve a functionally similar thing. Another issue is are we willing to live with both the big hits and the big misses in the sector, though, that would inevitably follow? We always have this conversation from the perspective that there'll be profits to actually distribute. There's going to be a range of hits and misses. I think that's something we need to be mindful of. Would this contribute to mission drift? For-profits already debate, do we pay dividends or reinvest in the business? But charities would be balancing incommensurable things. Do we relieve poverty or invest in the business? And I'm not putting to these to you as settled, as though I have settled answers, but I do think those are things that we would want to be to think about. And the other thing, though, I just circle back as sort of a big picture guy. What is it that we're investing in with registered charities? Is it just the goods and services that charities supply? Because if the answer to that question is yes, then to quote a famous tax phrase, then a buck is a buck is a buck, and we should care less about whether the buck originates from a donation or from a business activity, right? If we just care about the goods and services being supplied, and a lot of economists have said that that's all the charitable sector is. It's a remedy for government failure and private market failure. I don't believe that, frankly. I think that part of what we're investing in with charities is a culture of giving. That I think that it's not just the goods and services that charities provide. I think that there's something profound in us collectively validating, celebrating, and recognizing the choice to share. That choice to share through a donation is itself intrinsically important, independently of the goods and services supplied by charities. And I think we should worry about preserving that. Market transactions with charities may fund charitable goods and services, but it's not the same thing as the choice to share. I don't, and so I worry about us crowding that out as a defining feature of the sector.
And we seem to assume that everything that charities do is successful, and that's not true. I mean, there are certain things that happen in charities that people assume. Take the lotteries that charities sometimes get involved in. People assume that those lotteries are all successful. Some are very successful, but there are some that are huge drains on the charity because they've engaged in the lottery, but they had no idea what they were doing, and so they ended up losing money. They had to follow through in the laws of the lottery, which means giving away whatever the prize was, but didn't make any money in the process. So we shouldn't assume that. Mr. Euler, please.
I guess my first thought when talk about business activity comes to mind is that I think everybody agrees with that businesses have risk, and what is a practical way to assess that risk and to possibly avoid that risk. So, the answer seems to be that the current rule is that you would set up a separate corporate entity and hold the operation, the money generating operation in a separate corporate entity, pay some taxes. It sounds like most of it can be contributed to a charity, and at the end of the day, the charity would get a substantial amount of money if the business is profitable. The example in Australia that's alluded to sounds like there's a similar kind of setup, is that there is a distinct corporate entity. Again, in this case, it's a separate registered charity that the business operation is taken care of. That in my mind, I'm not quite sure if that means that the separate charitable entity has been separately financed, therefore it's not using any charitable assets such as donations and funding to possibly put towards the business, or in case of a loss that takes place, that it's using donations and funding. So I think that is potentially a model that could be looked at. And I think, but that would still sort of brings up the one of the drawbacks that the current rules have in place is that a charities, specifically small charities, maybe don't have the capacity to set up a distinct corporate entity, and that would cut into their capacity. But I think the Australian model again would sort of have the same sort of concerns or issues, is that you'd have to set up a distinct corporate entity, another registered charity with a separate board. So at the end of the day, perhaps that's a model that could be viewed at with those stipulations.
Cooper.
I'm actually going to pass. I think Adam Parachin said it way better than I could. Beyond indicating in a hierarchy, I think there are other ways to deal with this issue, and so this isn't on my sort of top 3 list of where some work needs to be done.
And on my list, I have Ms. Manwaring and Mr. Afterwatcher. Ms. Manwaring.
I don't want to sound problematic. I find some of the reasons that people object to the destination of funds test to be a little paternalistic. I find that, I mean, I totally agree that there's risk in every kind of program and every new program that charities start. I mean, charities do research, experiment. There's a lot of risk, and the fact that they might generate revenues from some of their activities, or might find an opportunity to generate revenues from some of their activities that can support their activities. You're right, there may be risk, but I also think that there, with education and that we can, and providing a system that we could use destination of funds to solve some of the real problems that charities have as far as funding, and without requiring them to put in place complicated corporate structures. What comes to mind a lot for me is that the clients that come to me with revenue generating opportunities where they're questioning this are organizations that are doing things like training people to work in, let's say, catering or restaurants, and they realize they can operate a little revenue generating business or some kind of an activity that relates similar to what they're doing, but is just purely to support their activity, but also allow them to make some extra money. And destination of funds allows us to work with them and to allow them to access this. It's not, there are a lot of reasons, or there are a lot of concerns that are valid for for-profits or not-for-profits. I just think for for-profits, we don't restrict them from, they get lots of tax incentives, they get lots of benefits from the government to do things in certain ways, and write-offs and that sort of thing, but nobody questions which business line they go down, and I sometimes get concerned when we start doing that with charities.
Senator Omniver.
Should a review of the destination of funds test related, unrelated business activities, should this be a priority for the CRA advisory panel?
It could be. I mean, I think the question, the purpose activity question brings up, if you go to purposes and we adopt to purposes, there then comes a question of, okay, what activities or what kind of things do we want to limit in some way? And revenue generation, and I'm going to call it revenue generation, not business on purpose. Revenue generation is one of those. So we have to come up with a solution for what, if any, limits there are on revenue generation in the context of the going with the purposes proposal. So I think it is something that needs to be considered and reviewed. And I really think in Australia, if you look hard, it has not been a negative. It is actually, the world hasn't, stopped their real disaster. So maybe there's something to look at.
Mr. Afterwatcher.
Well, I would certainly agree. In my practice, the destination of funds adoption would make life easier for a lot of charities. But I think the difficulty, again, comes down to the regulation of the particular nature of charities getting involved in these kind of business/revenue generation activities. Charities, for example, can keep receiving the use of donations for a losing cause and continue that until such time as they throw in the towel or the donors throw in the towel. And I think that there are certain particular concerns that are related to the sector getting involved in unlimited business activity. This is coupled with the fact, and I go back to my original comment about the jurisdiction to regulate charities at all. It's a fundamental problem if you don't have the people that can regulate these activities and look at these particular issues at the table. Arguably, the related business rules within the Income Tax Act are unconstitutional because it doesn't have a direct bearing on the collection of an income tax. And so the authority of Parliament, is questionable, I would think. So the concern I have is in popping the lid off the bottle and then not having the mechanism in place to regulate it. I'm not sure what the situation is in Australia if the government has looked at the specific concerns of charities getting involved in these areas, but I would suggest that the issues are intertwined. And not that the destination of funds is a bad thing. It's certainly not, but it is intertwined with how the charities themselves will be regulated in getting involved in these businesses.
Parachute.
So you asked whether or not there should be further study of this discrete topic, and I feel like, having sat through a number of these conversations over the years, I would abstract your question one big step further out, because I think there's a prior question we need to ask and think about before we answer your question, which is, what's the point of charity regulation under the Income Tax Act? What is it that we're trying to achieve? Are you trying to preserve assets? Are you trying to economize a tax expenditure? Or are you trying to vindicate some idea or trait about legal charity? And depending on how you answer that question, you're going to go in any one number of different directions in the Act. My own bias is we've landed on the common law of charity. The common law of charity is incredibly enabling, and from time to time questions arise as to whether or not the Income Tax Act should supplement that for tax purposes only, either by including more things in the category of charity or limiting them. And that's normally done, in my view, to vindicate some idea about charity, which is why I have reservations about business activities. But people can agree to disagree on that. We're never going to agree on the right answer without a defined target.
Mr. Euler.
I just want to make a comment about competition, and it is brought up quite often that whether there is unfair competition, and I'm not quite sure that there's a great understanding that charities can charge fees in their charitable programs, which is, I think, separate from what we're discussing here. We're not talking about, a car fixing business. We're talking maybe about the YMCA or an accessible transportation system. And in my mind, any complaints about competition should be rendered moot, as clearly those charitable activities are meeting a community need that's not being met in the private or public sector. Where competition, I think, unfair competition can be brought up is if in the car fixing business, whether the charity financed that car fixing business by getting donations in place in order to, purchase a garage, then I think the garage down the road would then have perhaps a reasonable complaint about unfair competition in that sense. So I think perhaps if there's going to be further review of this, that perhaps the current rules as they are and all of the different revenue generation activities, and I've counted 4 of them, very distinct ones, are very much clarified, and perhaps first and foremost that the CRA policy is maybe made clear to charities, because I certainly get that a lot of questions about exactly what we're talking about in terms of business activity and distinguishing that from charitable activity.
Good. I'm going to now move on to a new question. And it says, do you think that the minimum disbursement rate for charities should be maintained at 3.5%? If not, at what rate should it be fixed? Ms. Cooper.
You skipped one. Direction and control.
Well,
Okay.
No, I didn't actually. I read the question, and I thought that I might get a little different debate on this one. I may go back to it. I haven't finished. Just because it's written that way. Hey,
And on this one, then, I have
this is
no
the
position.
this is the benefit
How's
of being the
that?
chairman. I can skip around. Go ahead on the disbursement question.
Absolutely no position on that one.
Ms. Anwar?
The only thing that I would remind all of us, and this is thanks to Mr. Wyatt, who I think is sitting behind me, who I spoke to about this question, the disbursement quota used to be 4.5%. And some years ago, it was reduced to 3.5%, but that was done after a review, careful and considered review of sort of the investment returns and disbursement rates and how organizations did over quite a lengthy period, perhaps 20 years. And when it was reduced, bonds were the Canada Saving Bonds, I think, were still higher than 3.5%. So that it was reduced below the Canada Savings Bond rate. I don't see a reason necessarily to change it, but I think Canada Savings Bonds are now at 2.5%. So if you were following that theory of they changed it, but it was below, you might reduce it rather than increase it. But in any event, I think it's a complicated question that really requires careful review, and it does fit a little bit into one of Mr. Aptowitz's comments here, is that constitutionally and at charitable law, gifts can be subject to restriction on payouts, and you can only pay out income, not capital, and you couldn't change that under the Income Tax Act.
Ramnavar.
To any of you, probably more to Susan, because I know she has a point of view on this. Why is the disbursement rate embedded in the Income Tax Act as opposed to in regulations?
I'm not sure.
Should it be
But-
in the Act, or should it be, I mean,
Well,
we
if
deal
it's-
with enough legislation here so that, we've come to experience there are certain things you put in regulation to enable flexibility, timeliness there,
yeah.
because, it's all transparent, but you leave that up.
Many prescribed rates are in the regulation, and so that may stand for you could change it, put it into regulation. My only caution would be doing that doesn't mean it should change a lot.
Yes.
Because I think it's a very complex question as to what the right rate is based on how gifts are structured and how returns are. I mean, we've come out of a very low rate of return environment. It would be.
I think the answer to that question depends on, again, what are you trying to achieve with the disbursement quota? And one of the points that Susan made that needs to be kept in mind is income tax law exists alongside an accessory body of private law that donors are availing themselves of, in many instances, to establish an asset lock that only the annual yields, the annual income can be spent down. And so, having regard to that, I've always construed the 3.5% disbursement quota as a mechanism for requiring payout of annual returns. And if I'm right in positing that, then I would think that it would be an amount prescribed by regulation that corresponds with changing rates of return from time to time. It is odd that it's embedded in the Act.
Can you help us understand, because I don't remember, what Australia does with regard to disbursement rates, or the UK? Is it in legislation? Is it in the regulations? Do they have a disbursement quota? Yeah, I imagine. Okay, let's move on.
Nobody's taking up on that, Senator Arnold. But I am going to take direction from the panel and go backwards here, so that I don't get chastised again. I actually didn't like the question. That's why I avoided it. To be quite frank with you, many witnesses discussed the Canada Revenue Agency's guidance on direction and control, which specifies that charities must undertake their own activities. In considering alternatives to the direction and control approach, Ms. Eakin noted that other countries used an expenditure responsibility test that holds a charity accountable for their funding decisions without requiring the charity to do it all themselves. How, if at all, could an expenditure responsibility test be incorporated into the Canadian federal regulatory environment? And the second question is, what are the potential advantages and disadvantages of an expenditure responsibility test? Now you know why I skipped it. Mr. Parrish.
My colleagues will have more to say on this than me. I just want to highlight one point, which is the fact of the question only arises because the Income Tax Act, for reasons that I'm not sure anyone really fully understands, requires charitable organizations to further their own activities, to carry on charitable purposes through their own activities. And that's the context for why activities carried on abroad through partners raises this question. And so it's just one example. Whatever discussion is going to follow from this, the genesis of this is an ill-conceived reference to charitable activities in the Income Tax Act. And I'll leave it to my colleagues to resolve a better answer. But I think it's important to highlight that you don't like the question, and I don't think the sector likes the question either. But it originates in a drafting something subpar in the Act.
Something subpar to drafting of government. You heard it here first, folks.
Wordsmith, a diplomatic way to.
Well, we appreciate your diplomacy, but Ms. Cooper.
And part of why I was disappointed that we skipped it is because this is an issue that's on my top 3, right? And its roots are back in that whole activities thing, as Adam just explained. And they've conflated a requirement to carry on your own activities into a complex, oftentimes, I'll say it, shell game, to comply with requirements that CRA has made up. And I say it respectfully, to fill a vacuum, because what does carry on own activities mean? So many people try to transfer resources out to other entities to do the work. We need to put a frame around how that is done. And it's created a whole regime that I spend way too much time on trying to get organizations to comply, the reporting requirements, the drafting, and if you flipped it, instead of a requirement to carry on your own activities to a requirement to just simply be accountable for how those monies are spent, right? So you transfer the funds to the other organization to engage in the activity. Your accountability is simply to ensure and to be able to demonstrate that the funds were spent well, that they were properly spent on the activities that you intended to have them spent on, rather than creating a perception that somehow this other entity is doing the work on your behalf. And it's one of the issues that causes organizations to circle around and around, and I'm regularly on the phone with American, English, Scotch, Irish counsel trying to explain how backward our rules are in this regard compared to the rules in other jurisdictions. And, you understand from whence the rule comes, but it really is an overconflation of a tiny, tiny little requirement.
We may be the greatest country in the world. Doesn't mean that we have the greatest writers of legislation in the world. Is Ms. Manwaring?
I totally agree with Karen and the comments that are being made about this. And one point is that it's often brought up in the international space, and certainly in the international space, if you speak with Global Affairs Canada or others, the notion that we would try and direct and control the parties that are being supported in some of the countries in the world is seen on the ground as offensive by them. So it is really a game where, we're trying to show CRA something that on the ground the organizations could not even begin to suggest that they would have that kind of thing. It would be considered offensive. The other point I want to make about this, and it does come back up in a later question, this is true. These rules apply, and this issue is applicable every time a charity works with a non-charity on a project. So these issues come up in Canada. They come up often when Canadian organizations are working in the North or working with Indigenous groups who are not normally registered charities. They have their own different categories, but they may not be qualified donees. So it's a very important issue, not only for that the group of registered charities working in the international development world, but also organizations who are working on the ground here and trying to do things to support organizations and people in Canada through organizations that are not necessarily registered charity.
Yeah, I should declare my conflict because my son and daughter-in-law both have master's degrees in international development. So,
You hear about this.
no, I don't actually.
Well, the other point, one last point I would raise is we have a very significant client who has described for us the percentage of, or the amounts of money they spend annually on the administration, trying to prove direction and control. Like out of, a funding bucket of $1 million, they may end up spending through all the different organizations, the staff time and everything, almost up to 10% on just trying to make this work. And it seems like it's a poor expenditure of resources.
Well, it's interesting that we're at the end of this study here, and coming into the study, this was an area that I wanted to explore, and I kept waiting for witnesses to take me down that road, and nobody really did, because it is an issue. The cost.
I think we all thought someone else was doing it because
Yeah,
it's.
well,
I
yeah,
think
the
as Karen suggested, it is a top priority. I think
yeah.
across all witnesses. I do want to make one more statement. I think the expenditure responsibility type regime has worked for other countries for many years. Ours is the outlier. So I don't believe that this is something new and different that we're recommending here.
Mr. Apteweiser, and then Senator Ongever.
Yeah, at the risk of echoing my colleagues' comments, I think I know the guy that wrote that own activities bit. I'm not sure he would agree it was subpar, but it was. I think the idea really.
Yes, he is.
In fact, he is a lawyer. But at any rate, the one element I think of the control and direction test, which is proven useful, is the idea of explaining the fact that the federal government, by virtue of the donation tax credit, is effectively subsidizing donations. And so the idea that it really gets underlined that that accountability has to be inherent into the spending of the money. I'm not in favor of the control and direction test. It is, as my colleagues suggest, in some cases a bit of a farce to suggest that Canadian involvement in an international project in a minority level, that they should have control over the project. It's simply unworkable in many circumstances. It's certainly offensive in many circumstances, and really it doesn't do Canada any favors. Whatever test does replace it, as I hope this committee will suggest, does both accentuate the idea that the Canadians are accountable for the spending of the funds, but also portrays to the world, to the Canadian government, that they the funds are being spent as they were originally intended.
Ms. Manwaring.
Sorry, the first question here, and I think this goes a little bit, Senator Mercer, to what you were saying, is you've been waiting to hear about this, but I realized we didn't tell you, or we didn't make a recommendation as to what could be done. And I think the two key things to understand here, first off, the words direction and control are not in the Income Tax Act. They came out of case law, and my colleagues are right, it really was driven, I think, by the definition of charitable organization and the concepts of charitable activities carried on by it. So assuming you pick up the recommendation about purposes and activities and changing those definitions, that piece would fall away to a certain degree and give CRA the ability to move to an expenditure responsibility regime. The second thing is that in their wisdom, at some point, the government's added a prohibition in the Income Tax Act about registered charities making grants to non-qualified donees, and that would have to come out if we were going to go the expenditure responsibility route, because in effect, you would be making grants to non-Canadian charities. You would just be getting reports and expenditure reports that would show you they're being spent to further charitable purposes. So those two the provisions which are in the Act that say you cannot make those grants to non-qualified donees would have to be removed from the Act.
I would contend that there's a need to audit the demands of the CRA on all information that they request and demand from charities to see the benefit, not just from a cost point of view, but a benefit to regulating. Charities give the government all this data. Is it of any use to them? And on an ongoing basis. And if it's not any use, why are they demanding that charities provide it, and then analyze how much it costs for charities to produce it? So there would be a strain on the sector of spending money to produce information that nobody quite needs on an ongoing basis. Who's next? Oh, sorry. All right, next question, I guess. Senator Omniver, I apologize.
You're having such a good time. We're all
I'm having so much fun here. Yes. Listen, it's not very much often that a non-lawyer who gets to sit here and question 5 lawyers on an ongoing basis, and they can't leave. I got them. or as Kevin pointed, or charge me.
Thank you, Chair. So I've worked in charities and foundations literally all my entire life before I became a senator. So I understand really well what direction and control means, and I also understand and I can imagine the loosening of the constraints if we were to go to an expenditure responsibility test. One of our challenges is always we legislate for the main, not for the avenues or the tiny paths on the side of the highway, but there are risks. Could you advise us on how we manage those risks? Because it is possible that in certain circumstances, substituting direction and control for expenditure with an expenditure responsibility test could see charitable funds being used for purposes in activities that are not for. Is there some limitation? Is there some caution you would exercise?
Ms. Cooper.
I think you manage the risk by replacing it with expenditure responsibility, because the risk is that the funds will be spent wrongly. The risk is, there is a certain, current of concern with respect to terrorist, financing, those kinds of things. And at its core, expenditure responsibility is just simply ensuring that the charity is held accountable for how the money is spent. So I don't know necessarily that there's going to be that fewer books and records that are going to have to be kept. Yeah. It's just you're not going to be proving a fiction. Do you follow? You're not going to have to be proving that it was your activity. They're going to still have to, I would think, account for how the funds were spent. And with respect to the financial transactions, a good measure of that risk is already being managed through our FinTrack and other financial regulation systems.
I think it deserves to be raised, although I think we're all on side with this.
I think the difference in the reporting is that you can take the reporting from the organization rather than saying it's your own books and records. But I think we also have, and this is, I'm throwing this out there and might get some looks from my peers, but a while back we introduced intermediate sanctions into the Income Tax Act for charities, which mean there are certain circumstances where rather than the charity losing its charitable status, it can be penalized. And those penalties are, if they are in fact applied, can be satisfied by making a grant to another charity. You don't have to pay money to the government. So it's actually not a horrific system. But there may be something that says if you're not doing getting the appropriate books and records in a system like this, that at some level there could be some kind of sanction that so that there would be a disincentive for the charity.
Mr. Supervisor?
I would suggest that there's probably a range of options for control and direction depending on the nature of the activity undertaken by the charity. Under further thought, we may say that the nature of the control necessary on the distribution of alms for the poor in some part of the world is different than the nature of the control and direction we would expect of a large multinational organization engaging in some other activity elsewhere in the world. I would suggest that the fact that these rules are not codified in the Income Tax Act gives us a little bit of power to sit down and say, well, assuming that it's some other kind of a test, then what does it get replaced with? We give thought to the fact that there is room for nuance depending on the nature of the various activities being undertaken by the charities, wherever that might be. And it may be that charities are involved in multiple activities, and so they have different burdens to ensure accountability, but we don't necessarily have to have a one-size-fits-all kind of a test.
Thank you. Now, since I was chastised for skipping a question earlier, I want to remind people there are 5 questions I haven't covered yet, and we're coming down to some. Under the current rules, the required annual disbursement to qualified donees by foundations is applicable at the sponsoring foundation level, not at the donor-advised fund level. During the hearing, some witnesses expressed concern about the absence of reporting requirements on the activities of donor-advised funds and recommended that measures be taken to require or incentivize distributions in donor-advised funds to charities. 3 questions. What measures, if any, should the federal government take to require or incentivize distributions from donor-advised funds to charities? 2, do you support the introduction of a disbursement quota for individual donor-advised funds? And 3, what steps, if any, could the federal government take to improve the transparency of donor-advised funds? Mr. Euler?
So just to, so everybody knows, I am actually the only non-lawyer on the panel. Perhaps you've noticed my deferring to many of the topics to them to handle very well. So I'll offer a non-legal opinion, and perhaps I'm sure in spirit everybody would agree, but I'm sure they want to handle this in their professional manner. And I think everybody in the room would agree that I think you would like to see the monies being distributed at the donor advised fund level, would be my opinion. So certainly in support of movement towards that, and I guess looking at the logistics and how to handle that.
Thank you. Any other comments? Mr. Parashit?
I mean, I think the essential question raised here is how much ongoing control donors should have after the moment of gift. I mean, that's the essential question. And one of the arguments in favor of donor advised funds is that donors are at liberty to establish their own private foundation. And if they did that, they would, through the board, at the board level of a private foundation, have ongoing control. And so the question then becomes, so what's the problem? But there are a few responses to that, just in terms of framing the issues. One of which is at least the legal issue of whether or not a gift has been made. If you've not surrendered control over the donated property, there's a genuine legal issue there as to whether or not that's a receivable transaction. If you've got, for all practical purposes, control over the distribution of the funds moving forward, I think that's a live question there. I think there's also some complicated policy issues related to whether or not allowing donors continuing control over funds is an invitation to mischief. And the analogy at some level to the private foundation is, I think, imperfect, because we can regulate private foundations as private foundations. If you've got one foundation housing 300 donor advised funds, that poses some different regulatory hurdles to ensure that funds are being appropriately spent down. And I also, just as by way of providing context, the common law already provides donors extraordinary measures of control over donated property. You can impose, with the imprimatur and enforcement of law purposes, specific granular purposes that the funds have to be used for. You can perpetually, not 10 years, in perpetuity, which means what it says, require that the capital be held and that only income distributions be made. Where we've drawn the bright line is at that point of gift. That's where the control is supposed to sever. And so when I'm looking at this and stand back from it as a legal analyst, I'm left to ask, why is that inadequate for donors? Why do they have to have ongoing control beyond the point of the donation? And I'm sure that people that deal with donors on a day-to-day basis have an answer, but I think it's at least a worthy question.
Thank you. Ms. Manwaring?
And in the interest of time, and not feeling like, because I think there are arguments on the other, to respond to everything that Professor Parrish and Mr. Euler have said, I think that there is so much in this area that we don't know. There is a lot of speculation one way or the other, and I would hesitate making I don't want to sound repetitive, but I would think this is something that would need to be carefully studied. I think implications of saying it should be by fund basis or there should be disclosure is something that could have far-reaching implications in many charities beyond the benefit. So similar to what Senator Mercer was saying earlier, is the cost of trying to do something worth the benefit you get from it? I'm not sure. There are a lot of small donor-advised funds that have been set up by families in community foundations and others that are only, that aren't there for any nefarious reason except that it worked. And so I would encourage us to study that before making any concrete recommendations.
Senator Omnibus.
Thank you, Chair. We heard from one witness, I'm trying to remember, I think it was the Vancouver Community Foundation, who said they have a policy. At their community foundation, they hold, I think, many hundreds of donor-advised funds. They have a minimum disbursement policy for each individual donor-advised fund. To me, that seems, here's an institution that has been proactive and taken a step that others could follow. Is this something we should leave up to the community foundations of the world? But I do notice that there are $3.5 billion in donor-advised funds in Canada today. It's the fastest growing market in a way. So I wonder, do we do a bit of both?
Mr. Parrish.
Well, I mean, the rate of the payout to me strikes me as not the difficult question. And I want to be clear that my comments weren't directed at the obviousness of the answers so much as pointing out the difficulty of the questions. I'm not sure what the answer for this is, but the rate of the payout is, I don't think, the concern. Well, already as it is, the Income Tax Act requires modest payouts. I don't know why we would get more concerned about that in the donor-advised context than in other contexts. I think the concern is the ongoing influence over how the amounts paid out are spent, not the amount of the payout.
From what I know about this, and I have looked at this because it made me a little uncomfortable, that there is a huge amount of money that is basically in a parking lot. The money has been receipted, the donor has received the charitable donation deduction, but there is no requirement to pay out from the fund as long as it's in an aggregate, like in a community foundation where there are hundreds of funds. So if one fund pays out 10%, it equalizes everybody else, and there's the concern. So I think there is an issue here about getting charitably receipted dollars to charities to do the good work that they are set up to do, as opposed to parking it in a bank somewhere.
Ms. Manwaring, and then Ms. Cooper. Ms. Cooper.
My initial inclination was to respond to this question. This is not one of my primary concerns. And that is because, in part, as Adam says, it is so complex. And I say that because what is a donor-advised fund? And in my view, a fund where no income can be paid out may not be a gift in the first place because there is too much donor control. And the concern underlying all of this is absolutely we're seeing a multiplication of these donor advised funds. And as a lawyer, I'm not sure how many of them should have been receipted in the first place. And so it's a rabbit hole that I think takes much more study than you can do at this point, because I suspect you might be coming up with a solution that is almost too simple. Do you know? It's almost too simple to say, X percent out of every donor advised funds should now be spent, when I think the source is, in fact, a lot of these gifts aren't being structured correctly in the first place.
In other words, it's important for someone, the government, and that's perhaps a recommendation that we should consider, that maybe the CRA advisory panel should study the context of donor advised funds before we go down a particular path.
Mr. Aptois.
Well, I think certainly more study can't hurt.
you
But I think that
studying for it.
Sorry? Well, you could, yeah. I mean, I think before you're going to put together a set of solutions for one subsector of the charity community, you'll have to be very knowledgeable about what it is you're legislating. But I think that if you're going to get to that point and look at the distribution of the funds from donor advised funds and the control issues, you're inevitably going to draw in the idea of private foundations. Certainly on the control side, perhaps less so on the expenditure side, but it's a they didn't have to put it into a community foundation, which I would suggest by its very nature is interested in spending the money on the community rather than a private foundation, which does not necessarily have that same focus. So I would suggest that if you're concerned about those issues, then you're concerned about more than donor advised funds.
Okay, Mr. Pearson.
Just quickly again, I mean, the fact that the money's parked in a foundation is in my judgment, a red herring vis-a-vis donor advised funds. I'm not saying it's not a live issue, but that just circles back to the disbursement quota rate. Either 3.5% is the right number or it's too low. And I could very easily see a community foundation saying we've met the minimum payout. That's not where my concern is. My concern goes, I think, to Karen's point, which I wonder, it's a question, not a conclusion, whether some of these arrangements are creating agency relationships more so than tax receivable gifts. I don't know that for a fact, but when I hear what I hear, it starts to sound what in my legal mind I would characterize as non-gift. But I don't see it as a payout issue.
Okay, we have 5 minutes left, and we have the next panel sitting at the back of the room, ready to take your seats. So I'm looking for a question that will help it. I'm going to go to the end, the final questions. Throughout the study, several witnesses have expressed concern about CRA's technical interpretations on surplus income held by nonprofit organizations. These rules have been described as raising the level of risk for non-for-profit organizations by establishing a higher standard or benchmark for the not-for-profit organizations to avoid taxation on any surplus of income over expenditures. What measures, if any, should the federal government take to address, clarify, or amend the rules governing surplus income held by NPOs? Mr. Aptois.
This is a difficult question. Well, that's right. I only answer difficult ones, so we're on the right side. So the fundamental problem is that we don't have good data, at least not in the hands of the CRA, about the extent of the not-for-profit world. For many years, in fact, these organizations did not even have to file tax returns. And so it was only fairly recently that the CRA, realizing the paucity of information, started enforcing the requirement and collecting the data. Even the part that that not-for-profits were required to file was not enforced, and so we left with a general lack of information. As I said, for many years, the rule was that not-for-profit organizations could have 1 year of operating revenue. But realizing that this was sort of a one-size-fits-all approach, the CRA's current approach is a lot more reasonable in trying to suggest that there are variances amongst different areas of the not-for-profit world. I think one of the things that the CRA Advisory Committee may want to do is undertake a deeper review of this area as one concrete suggestion that could be the first step. But over and above that, the problem that exists for these organizations from a technical perspective is the idea that if they've amassed too much money, then that's suggestive of the idea that they're not really a not-for-profit organization. They're doing something which is amassing money, subject only to some sort of windfall gain, which happens from time to time. I would suggest that this is not necessarily a logical conclusion to draw from the fact that they've got money in the bank, and not necessarily a bad thing that they've got money in the bank. If they're charging a even below market value fee for a service that they may provide, but is taken up by a large number of organizations, or let's say customers, it's not necessarily true that they're operating for the purpose of a profit. It's just so happens that they've done well in a particular year or with a particular project. And so perhaps the right thing to do is to go back to a destination of funds test or something like that for the not-for-profit world as well. It's not, and look at the options available to us.
Thank you very much. I've got room for one response from Ms. Manwaring, and then we're going to have to adjourn for the next panel, folks. And if good, Ms. Manwaring, you have 2 minutes.
We ran, first off, nonprofit organizations in this question are the non-registered charity nonprofit organizations. Just making sure that's what I'm talking about, and that's what Adam was talking about, I'm sure. And I think this actually ran well for a long time until CRA rulings somehow got a hold of it and went in a little bit of a tangent. And I think they've come back and we seem to be in a better place. But that's not to say that the question of whether nonprofit organizations that are not charities should be tax exempt isn't something that could be looked at. In fact, the Department of Finance was about to release a consultation paper, I think in 2012 or 2013 on this topic, and it never got, after then Minister James Flaherty resigned as finance minister, it got shelved. But a study on this area could be helpful, and what it would do to the I don't think surpluses are the damaging piece. It's really a much bigger question than that.
Thank you. I'm going to cut it off there, but I am going to make a suggestion. You have a list of the questions. Questions 10, 11, and 12 are questions that we didn't actually get to in any detail. We would welcome your response in writing if you have if you're so inclined. But I want to say that we are tremendously grateful for your time today. And particularly the fact that we have 4 eminent lawyers and someone else who's added an awful lot of good opinions to the debate. We thank you for that, and we hope that some of your comments will be reflected in our final report for your edification. This is the last series of meetings we're having. We're going to meet with another group in a few moments, and then the hard work goes to these 2 ladies to my right from the Library of Parliament to start writing the report, and then reviewing it on an ongoing basis with us and trying to reflect what we've heard. But you can be assured that whatever the final report is, you've had a major effect on. So thank you. We're going to stand adjourned for a few minutes while Clerk organizes the new panel. Thank you.